Well, the Senate today heard from a retired Supreme Court justice and a Canadian legal scholar that there may be some legal problems with the government's proposed legislation to bring Canadian laws in line with the United Nations Declaration on the Rights of Indigenous People. Bill C-262 is currently before the Senate's Legal and Constitutional Affairs Committee. Today, committee members discussed a brief by former Supreme Court Justice John Major, and they also heard from Dwight Newman. Mr. Newman is the Canada Research Chair in Indigenous Rights in Constitutional and International Law, and he's also a Senior Fellow at the Macdonald-Laurier Institute. He testified by teleconference, and he's joining us now from a conference in Oxford, England. Mr. Newman, thanks for taking the time.
Oh, I'm happy to talk with you.
Okay, let's start with the basics. I want a first basic question. If we look at Bill C-262, which aims at bringing Canada's laws in alignment with the UN Declaration, in principle, are you in favour of the goal of the legislation?
Oh, the goal is a very important goal. Obviously, the UN Declaration on the Rights of Indigenous Peoples expresses a consensus of the world community in many different ways, and pursuing the implementation of the objectives of the Declaration is a very important step for Canada.
So for the layman then, because we're not all legal experts, and your testimony was very much of a legal nature, you say there's potential problems with the bill, because it simply says that the UN Declaration has application in Canadian law as the expression. You say there are problems with that formulation.
Indeed, yes. So part of the bill is oriented towards a longer-term implementation effort through an examination of different statutes and amendment of those through Parliament. But there's a part of the bill that says that the UN Declaration on the Rights of Indigenous Peoples has application in Canadian law. And that's not a terminology that's usually used in a statute. In fact, I can't find any prior example of that exact terminology. But some of the possible interpretations of it would see the courts trying to apply the declaration directly into Canadian law with very little guidance on how to go about doing that. And so I think that that could have some unexpected consequences, and isn't the way that the bill was explained either in terms of what it's supposed to be doing. So that section struck me as a section with some issues with it. You
also said that there was an issue. I want to sort of peel back the layers of that onion. But you also said there's some concern about it coming into effect immediately, whereas the governments of Canada have always said no, that this will have to come into effect bit by bit.
Right. So there's a lot to work through in terms of doing the work that's necessary to implement the Declaration and to implement Indigenous rights better in Canada. That's very important work. Unfortunately, it can't be done overnight. And the government, of course, has said that. The proponents of the bill have said that it's not intended to have immediate application. But Section 3, that clause on the application in Canadian law, is in the present tense. It reads as if it would have immediate application, and see the courts in a position where they're under instructions to immediately start implementing the declaration. And that's not really the way the bill was explained, and it's probably not capturing the intention of the bill. It could be better phrased, and the bill could be amended in order to better implement its own purposes.
You're saying, you mentioned unexpected consequences. You're saying that this bill, if it applies, it can have unexpected consequences. You mentioned two things. You mentioned the issue of free, prior, and informed consent. And you also mentioned the issue of existing jurisprudence in terms of property rights and things like that for Native people in Canada, Indigenous people in Canada. What are those concerns?
So the meaning of free, prior, and informed consent is still developing in international law. There are some good accounts of just what it means and when it applies, but they haven't received complete agreement as yet. So Canada has a very sophisticated system on the duty to consult in current Canadian law. The addition of a free, prior, and informed consent requirement could have quite unpredictable consequences for that system. And to the extent that the bill is calling for an immediate implementation by judges, there are some real problems with doing that in terms of building on the strengths of the system that we already have in some ways that that could move forward, I think, more effectively than immediately shifting over to a different system. The other aspect there is just that the rules on Indigenous land rights in Canada, as elsewhere, are in an ongoing development. And again, the bill could introduce some immediate changes there in a way that isn't necessarily being developed as carefully through Parliament if it's through litigation based on an immediate application of the bill.
You seem to suggest, I mean, I was reading through your brief, and you seem to suggest if some of the unintended consequences come through, you seem to suggest that a lot of those things like the land claims negotiations, but also things like the rulings on pipelines and the necessity to consult, those things could be challenged by this new legislation.
It certainly could shift the legal rules that apply to something like pipelines, and that raises some issues in terms of the predictability of the Canadian legal environment. Obviously, we're working towards better respect for Indigenous rights and consultation with Indigenous peoples, and the case law has been doing that. But this bill has the potential to effect some sudden changes there in a manner that's much less predictable than it could have been. Again, through some amendments to the bill, a lot of these issues could be lessened, and I think the bill could attract support from everyone in an amended form.
So what you're saying is that you have no problem with the intent, but there's a question of refining a lot of the clauses, so you don't have what you call these unintended consequences.
Right. I think in terms of some of those at a larger level, there needs to be some refining. I've also pointed to even just some technical issues with the bill. Some of the sections in English and French actually aren't rendered consistently with the way that the terms are normally translated between the two languages in other statutes. So there's some inconsistencies like that to clear up. There's some particular language, particular phrases within the bill and I'm not the only one to point this out. There have been other legal scholars to do so, but particular phrases that simply aren't the usual terms of art used in statutory drafting. And so the bill could be improved by actually making use of the normal terms of art used in statutory drafting.
Okay, well, I want to thank you very much for speaking with us. And obviously, if you're before the Senate and the bill's before the Senate, this is the kind of refinements or fine-tuning that is often suggested at committee. I want to thank you very much for joining us from Oxford, England.
Sure, happy to talk with you, and I hope we'll have good ongoing discussions.
Okay, well, watch this. Thank you very much.
Thank you.